Hello, I'm Gary Bruce. You're watching this because we have been asked to mediate your case. Now, what is mediation? We'll spend some more time talking to you about it in person as we get ready, but mediation is a form of alternative dispute resolution, which has really been in vogue for the last 20 years. Actually, when I went to law school in the early 80s, it was also discussed, but it was never implemented really until we saw it recently, and the courts have embraced it. Here in this area, the courts are going to order us to mediation. It's mandatory before we can get a trial. They want to see whether the case can be resolved. And the truth is, it has changed how cases go forward. Now, as you know, it's rare that we have a mediation before a lawsuit's filed, but sometimes we do. But I assume you're watching this because we had a lawsuit. They've taken your deposition, we've exchanged information, they have all your medical records or all the pertinent documents, and we have the same. And now we hope to go to a meeting where we can all get together with all the decision makers and see if it can be resolved. My goal in going to mediation is to define your options. We'll learn more about how the defense sees your case. We'll learn something about how they value your case. You'll get to ask questions, give testimony, be heard, and make decisions. There is no definitive answer given that day. We'll simply find out where we are and how far apart we are. So it's an opportunity to be heard by the person who's evaluating your case for the insurance company. It's not a jury, and they may think differently of it than a jury would. On the other hand, it does give us an opportunity to be heard with a third-party mediator. Now, what does the mediator do? He doesn't care who gets what. His job is to get a deal. Remember that. He's a deal maker. He is coming to bring us together. So the process is this. We will all sit together in a room. We will present your side of the case to the extent we feel it's necessary. We'll hear something from the defense. The mediator will then put us in separate rooms. He goes back or she goes back and forth all day if necessary, discussing points, talking about the case, relaying offers and demands. And at the end of the day, we'll know something more about where we stand. It may not be resolved and it may not need to be resolved, and we may just leave without a deal. But many times it is an opportunity to get something behind you. So we will set up a time to talk. We'll talk about numbers then. We'll talk about your testimony. Your prep should be to think about how this has impacted your life. That's the thing I want you to relay to the decision maker and the mediator. So no sweat. It is not recorded. It is not a judicial proceeding, but it is an opportunity. So think about those things, come prepared with an open mind, and we'll see what we can do to hopefully bring your case to a close. Thank you.